All right, welcome back. Amber Guyger trial, former police officer on trial for her life for murder. Folks, this is such an odd case where there she is as a police officer. She got done with a 15-hour shift, went to her apartment building, went to the third floor as opposed to where she lived on the fourth floor, directly to the apartment underneath her apartment. And the door opened and she fired shots because she believed that the victim was in her apartment. You see a picture of them there. Poor guy, innocent guy, doing absolutely nothing wrong and shot and killed by the officer who thought that he was in her apartment. Guys, this is going to be an unbelievable case legally, and we can't have anything better than the professor. And now, included on that, is the great legal analyst here at the Law&Crime Network, Gene Rossi, 30 years at the DOJ. He's trained over 1,000 prosecutors. Welcome to the show, Gene.
Good afternoon. Thanks for having me.
Good afternoon, Gene. Just to put you up to speed, because you were a little tardy today, myself and the professor have already gone over what the indictment is with regard to murder with intentional, knowing, reckless, and criminal negligence there in Texas. And they have a lot of varying language. And it's very, very important that our baby prosecutors and our defense lawyers know what the law is that the jury is going to hear at the end of the day, because it's not about what you feel. It's not about protests in the street because you feel that the officer did anything wrong. It is about this police officer entitled to proof beyond a reasonable doubt with a presumption of innocence, and whether they can prove those elements of those offenses, as we call elements, ingredients, like baking a cake, beyond a reasonable doubt. But Gene Rossi, as you know, there are not just the law, but there's also in the criminal world affirmative defenses. So I'm not going to hit you with a heavy one right now, because I know the professor is actually in the process of teaching his law students some of that. Now, the ones that I see, we'll deal with the more difficult one in a minute, which is self-defense. But the one that popped right out to me from the beginning is mistake of fact. Okay, now this is what an affirmative defense is. What an affirmative defense means is that even if you did everything the prosecutor said and they prove it to you beyond a reasonable doubt, if it can be proven that this affirmative defense exists, like self-defense, that's the one most people know, then it results in a not guilty verdict outright. So, Professor, you talked and brought it up also about mistake of fact, section 802 out there in Texas, where it is, ladies and gentlemen of the jury, it is a defense to a prosecution that the actor, through a mistake, formed a reasonable belief about a matter of fact if his mistaken belief negated the kind of culpability required for the commission of the offense. And I just want to add to that, because we want to be thorough, although an actor's mistake of fact may constitute a defense to the offense charged, he may nevertheless be convicted of a lesser included offense of which he would be guilty if the fact were as he believed. A little complex, and I always feel this sometimes when I'm trying a case, whether it's a prosecutor, defense lawyer, the jury has read these jury charges, and sometimes I wonder, like, how, I've been doing this for 30 years, how are they getting it? But can you break that down in layman's logic, parlance as to what a mistake of fact as an affirmative defense is?
Sure. So first of all, just, I'll get back to it. That term reasonable, that's what we earn our keep as lawyers. So, it means that the defendant had a mistaken belief of the circumstances as they were. So, in short, you walk up to me, you're approaching me to ask me what time it is, and for whatever reason, I think that you're going to attack me, and I defend myself. That's a mistake of fact. Now, is it reasonable that when you approach me in the street to ask me what time it was, I should think that you were going to attack me? Not necessarily. And that's what's the question here for the jury.
Yeah, I agree completely with the professor. Gene, with regard to the word reasonableness here, what are your thoughts? I mean, clearly the defense is going to say she wound up at the wrong apartment. Well, we'll have to wait to figure out what that is. I don't believe there's going to be any indication of drugs or alcohol here, because she had just gotten done with her shift, but we'll have to await those facts as well. She made a mistake and went to the wrong apartment. I get it. It's odd, it's peculiar, it's weird. But if the jury were to believe that she believed at the time she went into her apartment that there was a person inside of her dwelling, could that raise a potential affirmative defense of mistake of fact?
Yes, and if they find that she actually thought reasonably she was in her own apartment, then there will be a hung jury or an acquittal. This is an egregious case. And I want to go back to what you said, Bob, about trial notebooks. I totally agree. The first two tabs in your trial notebook should be the indictment, of course, and the second should be the jury instructions. Because when I used to present cases to the grand jury and supervise my baby prosecutors, they always read the elements of the crime to the grand jury before they went into the room alone and deliberated. So those two documents are absolutely crucial. And I think if they find that it was reasonable for her to think she's in her own apartment, then it was reasonable for her to think that that was a burglar who could cause serious bodily injury or death to her. As tragic as these facts are.
Yeah, and Professor, kind of getting back to what I was saying before, and Gene said as tragic as these facts are, and it is tragic, he's by all estimations, a beautiful guy, doing the right thing, was in his own place, minding his own business, and he's shot and killed. But getting back to the point that I was making before, there is a difference between criminal culpability, criminal responsibility, and an accident.
Oh, absolutely. And that's why, theoretically, why we have affirmative defenses and these types of defenses under the law. Because as heinous as they may be, accidents do happen. Bad things happen to good people, and it's no one's fault. And it's all about whether the defendant is blameworthy, whether they should incur criminal liability or not. And that's what this case is going to turn on. Just wanted to raise another point. I think her background and whether that will whether that's something the jury will be able to consider will be wildly important. Will she be considered under a reasonable person standard or under a reasonable police officer standard? Two wildly different things.
Right, right. Excellent points. And let's just make sure our audience understands that this trial is about to get underway. There's going to be opening statements. There was a motion for a mistrial that was made by the defense. And guys, let's just take a little sidebar here because we have the ability to be able to do that here at the Law and Crime Network. We can take our sidebars this week. That's the power of the host position. Man, Gene, I'm going to go to you because you have extensive experience as a prosecutor, and I, who led an agency for many years. The last thing I'm doing as the district attorney, in any case, I didn't do it, period, but especially the day or the couple days before the trial, is start making public statements about the case, especially when there's been a motion for change of venue. And this violated a gag order of the judge and provided the defense attorney with a motion to have this case thrown out. Now, I doubt that that is going to happen, but why is it that these prosecutors can't stop getting behind the mics and talking about cases where they're supposed to be tried in the court of law, not the court of public opinion? Rossi.
I think, I got to tell you, that motion for mistrial, that had legs. Because right before trial, in light of a gag order and a change of venue, I got to say this on television, that was reckless, it was premeditated, and it was disgraceful what he did. But Bob, this is the same state that has the photo of the victim behind the witness box throughout the trial.
Yeah, and it's the same. Yeah, Gene, we can't get that out of our head. That may have been the Magic 8-Ball case. I'm not really sure. But you have that, and you have a state that didn't even require unanimity with the jury when imposing the death penalty until that literally got changed. Really tough territory. But, Professor, I ask you, I mean, the judge has a lot of tools at their disposal how to handle it. If it were me, yours truly sitting there as a judge, I wouldn't dismiss the indictment because of it. I can certainly dear the jurors to make sure that they didn't hear anything and that they haven't been, poisoned that way. But I'll tell you what, I'd sanction him and consider referring it to the ethics committee.
Certainly, and not to mention the jurors are under extreme pressure here. This is a rather sensational case in that community. I think that's probably part of the reason why the prosecutor felt compelled to go before the cameras, because everybody is asking questions and they want to know where they think this is going. And it's really tough on the jurors. So I would agree with Gene that you really have to, it's irresponsible. You have to be sympathetic to, first and foremost, to the jurors.
All right, Gene, I'm going to throw the curveball at you this way as well, because we can go into a lot of different places, because we've been around the block, all of us here. I love having you guys on as guests. This is why I say over and over again, I am in favor of prosecutors appointed by the governor as opposed to elected by the people, because this case was charged as a manslaughter, got upgraded to a murder, and I have to say there was a lot of protest before anybody knew the facts, before anybody knew what occurred here, before anybody listened to the statement of the defendant. They quote unquote wanted justice, and sometimes these elected prosecutors like Michael Nifong and others that I'll let remain nameless wind up letting the tail wag the dog. What do you think, Gene?
Absolutely. I am totally against elected, I'm even against elected judges. It's not a perfect system, but it's better to have appointed prosecutors and judges, number one. And number two, and this is a proposal I put out in the state of Virginia, if you have a murder, a police homicide involving a defendant who's a police officer, like here in the city of Alexandria, I would have that case prosecuted by a prosecutor 150 miles away. And in Virginia, they're elected, but at least you don't have that local political angle that you see in a lot of these cases.
Yeah, it's sad for me to say because I was appointed by the governor in my position, but and still there's a lot of pressure on you. And I would always say to my staff, our job is not to let the tail wag the dog. We got to make decisions. We're going to either make the right ones or wrong ones, but at least we'll make the ones we believe are honorable, and we'll be able to have our head held high. It is so much easier to do. And I don't mean to say all elected district attorneys are bad. Please, that is not my message. But I have just seen too much in politics and prosecution, which I always call, Gene, you've heard me say this, politics and prosecution, a toxic cocktail in terms of criminal justice, yeah, and in terms of justice in general. Guys, I love having my great guests here. Professor and Gene are going to be carrying us through this entire trial. Openings are about to begin. The judge took a little bit break to consider the motion for the mistrial based on the DA's extrajudicial statements, what we call them. And we'll be back shortly.